Today, I wanted to talk about a number of legislative statutes and cases that have interpreted them. Just brief synopses. The first is a presumption regarding amendments to a statute. In Dalton versus Baldwin, a 1944 California appellate court decision, the court said the presumption that a statutory amendment was intended to change the meaning of the statute applies only when there's a material change contained in the language of the amended statute. The next is knowledge of court decisions. And in Thomas versus Driscoll, a 1940 California appellate court decision, the Court of Appeal explained the fact that a lawmaking body knew decisions of appellate courts and made a substantial change in phraseology of a subdivision of the statute indicated an intention to effect a change of its meaning. The next is the legislature and its subpoena power. And in the California Supreme Court decision in Re Batelli in 1929, the High Court said a branch of the legislature had power to require and compel attendance of witnesses and the production of documents before it or its duly accredited committees. In terms of the power of the legislature to investigate its own members, the California Supreme Court back in 1866 said in the case of Ex parte McCarthy, the Senate has the power to investigate charges of bribery against its own members, and in the exercise thereof could summon and examine witnesses. In addressing the limit on courts, the judicial branch, and lawmaking, the California Supreme Court said in Serrano versus Priest in 1976, the courts may not order the legislature or its members to enact or not to enact legislation, nor may it order the governor to sign or not to sign legislation. Addressing bills that become law without the governor's signature, in the case of Diaz's versus Department of Motor Vehicles in 2003, the California Appellate Court said, when the governor allows a bill to become law without his signature, he is required to authenticate the bill by causing the Secretary of State to certify that fact and deposit it with the laws in the office of the Secretary of State. In addressing the conflict between two or more measures, the California Supreme Court, in the case of In Re Theory S in 1977, said the presumption established by Government Code Section 9605, providing that when two or more statutes enacted at the same section conflict, the highest chapter statute is presumed to prevail, is rebuttable and can be overcome by evidence that the governor actually approved bills in a different order than indicated by the chapter numbers. The highest chapter number rule does not violate the division of powers doctrine. When two conflicting bills are signed by the governor during the same session of the legislature, the bill signed last is the one which takes precedence. In describing the retroactive effect of a bill, the California Court of Appeal in 1978, in the case of Industrial Indemnity Company versus Workers' Compensation Appeals Board, explained a statutory change in the labor code, which is substantive in character, does not act retroactively absent a clear showing of legislative intent that it should do so. The legislative intent calling for the retroactive operation of a statutory change may be found in such factors as context, objective of the legislation, evils to which it is addressed, social history of the times, and legislation upon the same subject, public policy enunciated or vindicated by enactment and effect of particular legislation upon the entire statutory scheme of which it is a part. In describing the application of a statute retroactively, the California Court of Appeal in 1946 in Western and Southern Life Insurance Company versus State Board of Equalization said, the guidelines to be followed in determining whether a statute imposing civil penalties should or should not be applied retroactively are: one, A presumption that legislative changes do not apply retroactively in the absence of clear legislative intent. 2, a presumption that the purpose of the change would not often attain significant advancement by retroactive application. 3, the possible constitutional objections on the case of ex post facto punishment. 4, the doubt as to the constitutionality of retroactive application. And 5, the retroactive imposition of increased liabilities should carefully be avoided. In addressing the issue of severability, the California Court of Appeal in 1982 in the case of Manning versus Municipal County said, the test of severability is whether invalid parts of the statute can be severed from otherwise valid parts without destroying the statutory scheme or utility of the remaining provisions. Regarding the presumption of the last enacted statute, in 1971, the Court of Appeal in Western Mobile Home Association versus the County of San Diego explained, the application of the presumption that the statute which is enacted last is intended to prevail over statutes which are enacted earlier at the same session depends upon a real or at least apparent conflict or inconsistency between the two statutes. In explaining the use of clarifying amendments, the California Supreme Court in 1944 in Heiss versus McColgan said, under appropriate circumstances, an amendment to a statute may be made for the purpose of clarification rather than new matter or an alteration of formal law. Regarding the effect of a declaratory statute, the California Supreme Court in its 1935 decision of Clayton versus Schultz said, while a declaratory statute cannot bind courts with respect to the application of the original statute to transactions which occurred or rights of action which occurred prior to the passage of the declaratory statute, the statute declaratory of the former statute has the same effect as if it were embodied in the original statute at the time of its passage in the absence of any intervening rights. Regarding the statement of the legislature's inability to enact laws that tie future legislatures, the California Court of Appeal in 1941 in the case of United Milk Producers of California versus Cecil explained that generally the legislature cannot enact irrepealable legislation or limit or restrict its own power or the power of its successors as to the repeal of statutes, and an act of one legislature is not binding upon and does not tie the hands of future legislatures. The legislature cannot bind a future legislature to a particular mode of repeal and cannot declare in advance the intent of subsequent legislatures or effect of subsequent legislation upon existing statutes. In addition, regarding explaining the purpose of the reenactment rule in this state, the California Supreme Court explained in 2016 in County of San Diego versus Commission on State Mandates, the purpose of the reenactment rule is to avoid the enactment of statutes and terms so blind that the legislative body is deceived in regard to their effect, and the public from the difficulty of making the necessary examination and comparison, and fails to become apprised of the changes made in the laws.